I'm Harrison Brundage. I'm a retired petroleum geologist and technical writer, Houston. Good afternoon and welcome again to our first ever Houston annual meeting. I hope that my title, Quashing Fake Silicosis and Lupus Epidemics and Putting Out Huge Fires, has aroused your curiosity as to why a career geologist is so interested in these specific ills. My original title was How Fraudulent Silicosis and Lupus Epidemics Were Defeated in Texas Courts. Our wise president, Orient, not Obama, suggested that this change so that I could share my knowledge and experience too with a few of our spectacular disaster preparers and foremost hands-on global environmental workers and protectors, the oil well firefighters, in the same talk. I am humbled by the honor to address such a distinguished group of North American citizens among our very best, otherwise you would not do what you do. My degree is a journeyman's geology BA, hence I never even got close to a doctorate, but I had the superb good luck to be hired in March of 1948 on the Yale campus before my graduation in '48 to join the San Antonio exploration office of a major oil company and join the staff there. Oil well firefighters don't have doctors either, but we all owe them much, more than I realized before preparing this talk, as we cannot do and do not do what they must do. As a member of Corpus Christi Toastmasters Club during 1954-55, I was advised to get up, speak up, and shut up. With that said, here goes. Inept, I'll put this thing away. Inept, anti-science, anti-educational legal work and court system abuses involving extractive minerals seem to bring out the worst in too many participants and result in complex legalistic flails and decisions that satisfy hardly anyone. Hard cases can indeed make bad law. Two Gulf Coast legal initiatives of the past 20 years might seem better ignored by those not directly effective. Still, doctors complain bitterly about junk science-based lawsuits against medical professionals and costly liability insurance needed to protect against such tort abuse. The following summary of basic and some previously little-known facts may in time prove of value in placing some vital information and legal concepts into a single, accurately worded report for future reference. Courts do honor precedents. Some unusual ones were indicated here in recent years. Have the first slide? No, that's the second one. The first one is JAMA. Okay, that's it. Okay, this is an old JAMA publication that I will, you can't read it all, but I will just quote it. My father's work as a statistician with U.S. Public Health Service later merged into HEW, put food on the Brundage family table during the 1930s. One of my first memories of those are those of my father diligently working at our home in Arlington, Virginia, with a long mathematical slide rule, at least as long as this podium is wide. And it's been, it was the state-of-the-art technology at the time in which the Antiques Roadshow has since shown casual interest. As published in JAMA, July 11th, 1936, volume 107, number 2. This bulletin is titled Anthracosilicosis Among Hard Coal Miners. It is excerpted as follows. Quote, under an agreement with the mine operators, the mine workers, and the state of Pennsylvania, the Public Health Service selected for detailed study a group of mines in the anthracite district. The study of the dust exposures of the men included the nature of the dust, the size of the dust particles, and the dust concentration in the different parts of the mines. The dust exposure correlated with each occupation resulted in an estimation of the exposure of the men per week, per month, or per year. Occupations which were dust producing and lead to severe exposures included 53% of the men. Among men who did the drilling, especially the rock drillers, the silica content of the material rose as high as 43% of quartz. The greatest exposure underground was experienced by the regular miners and the rock drillers, unquote. Among listed authors are, from the Office of Industrial Hygiene and Sanitation, Surgeon R.R. Sayers, Engineering Studies by J.J. Bloomfield, Statistical Analysis by Dean K. Brundage, Statistician, and Rollo H. Britton, Senior Statistician. Yale alumnus Jack Bloomfield interviewed me during my senior year of high school and helped me with a regional scholarship in wartime when Yale was particularly generous with them. The Brittons were our next door neighbors. Mrs. Marion Britton helped me learn tennis starting in 1933. I grew up with her sons, Charles and Roy. Their pet collie played with ours. My mother told me subsequently that my dad's statistical work and other data from this bulletin and other similar work were the basis for some industrial insurance rates and provisions in the 1930s. So this was and still is serious business to this very day, as I will explain. Now please fast forward to the career of the late Houston attorney John O. Quinn. 1941-2009, he was 68 when he died, who merits praise for enlarging the big University of Houston Law Library, and particularly for winning a huge financial settlement for the state of Texas versus the tobacco industry. Though I am proud of my Virginia origins, something of which I am not proud is its big tobacco industry, a reason why I came to Texas as soon as I could upon college graduation. So I would have backed O'Quinn on that particular issue. O'Quinn liked to say, and I quote, "I love the law," meaning that body of it that enabled him to get very rich and rival as the king of torts, his words again, Houston attorney Joe Jamail, who won the $11 billion judgment for Pennzoil against Texaco in 1987. Post-tobacco litigation, O'Quinn badly overestimated his presumed invincibility in court and indestructibility on the roads. His defeat in the Silicosis litigation, intended to rip off sandblasting companies, sand quarry operators, and their medical insurance, followed his defeat by Chevron attorneys in the Lupus legislation. Some legalistic wags who might have known better put down a Chevron attorney, Robert Meadows, as a lightweight of whom O'Quinn would make mincemeat in court. Didn't happen. If there ever was a fine example of the street wisdom to the effect that if you believe your own baloney, you're in trouble, this is it. O'Quinn initially evaluated the Kennedy Heights lawsuit at $500 million. Second slide, please. So now, I better get this, see if I can get the pointer here. At this point, it's appropriate, the middle one, At this point, it's appropriate to show some local geography with the Houston highway system, sketch mapped with some landmark names arrowed for relevance. This isn't professional grade cartography, but should serve its orientation purposes. Indicated are the Marriott South Hobby. Marriott South Hobby, you are here. That's the Southwest Freeway. That's the Gulf Freeway there, headed toward Galveston. Then the Kennedy Heights subdivision, which is on the south part of Houston, it points up to there. The depleted Pierce Junction oil field on Holmes Road, there. It's near the Astrodome. Depleted Satsuma Fairbanks oil fields. That's up in that kind of grayish streak down to the northwest. It's close to my home sweet home neighborhood of northwest Houston. The downtown medical center and museum district, it also includes Rice University and the Houston Zoo, Reliant Park, and Stadium for Houston, Texas Texans football, Minute Maid Park for Houston Astros baseball along State Highway 59 that falls about at the I in Minute. The University of Houston at the 4800 block of Calhoun Street, about at the site of the U in Minute, and the Houston Ship Channel, farther southeast off the southeast of us, along the Gulf Freeway, I-45, or League City, a tidy Houston suburb where it sits atop a big field where I was a well site geologist on a good oil and gas well in 1980. Ellington Airfield, assigned to protect our channel industries, and NASA Clear Lake. Off the map is Galveston at the Gulf Freeway's end, and 240 miles to the south of us is Corpus Christi, which is a delightful city by the bay, by its bay. Now please fast forward to the Kennedy Heights litigation of the 1990s to the year 2005. Now sometimes we may suffer depression with getting the feeling that all the news is bad. Not so. There is indeed some good news. Enter federal judge Janice Graham Jack, a former professionally trained nurse turned lawyer, thereafter appointed a judge assigned to a Corpus Christi Federal District Court overseeing Gulf Coast federal judicial matters, including jurisdiction over health litigation of some Mississippi sandblasters. To make a longer story shorter, John O'Quinn and some affiliated lawyers churned out bogus lawsuits like so much mass-produced baloney, alleging diagnosed silicosis cases with x-rays obtained from Mississippi medical offices and misinterpreted by others who had not even seen any or all or any of the alleged silicosis patients. In one masterful fell swoop, Judge Jack summarily dismissed all of them from the O'Quinn attorneys, saying that only 76 silicosis claims had been filed in Mississippi in 2001, but 10,642 such cases were filed only a year later. Further, and I quote, "These diagnoses were about litigation rather than health care. It is apparent that truth and justice had very little to do with these diagnoses. Otherwise, more effort would have been devoted to ensuring they were accurate," unquote. The cases, in her words, were manufactured for money. Hereabouts, Judge Jack thereby became a folk heroine. X-ray interpretation was not then so different from when she was a medical professional trained and experienced in X-ray interpretation. She also denied a weak O'Quinn request to respond. She knows her business. You don't mess with a judge when you have no case. Following O'Quinn's death, additional issues came to light about this silicosis, quote, phantom epidemic, unquote, and flagrant mass barratry in probate court this past March. So this is pretty recent still underway. In late 2009, John O'Quinn was in a big hurry to retrieve a forgotten document timely for a meeting and drove his car 30 miles an hour faster than the posted speed limit on a Houston street. He lost control and crashed, killing himself and a passenger. Neither wore seat belts. Now that his estate is in probate, as recently as this past March, various other noteworthy issues are arising. They don't smell very good. It seems that some patients falsely diagnosed with silicosis were billed for expenses incurred by lawyers filing these bogus lawsuits. O'Quinn's estate had ample complexities without them, and that too, his longtime live-in lady friend seemed due an inheritance as a stated common law wife, and a warehouse full of classic and antique cars that had to be vacated from storage and sold. O'Quinn's executor, Gerald Treese, an honorable man, lawyer, and law professor, skillfully resolved the lady's claim to concentrate on more vital interests like raising car auction funds to pay off claims. As we know, hell hath no wrath like a woman scorned. So I grade Treese A+ for diplomacy on that touchy source, settling that touchy issue. Kennedy Heights subdivision, Houston, again, South Houston. This is a sad, convoluted story begun with some sloppy 1926 oil production practices near Pierce Junction oil field on Houston's south side. It was then flanked by prolific cropland. Even after several more recent 1990s years of torturous litigation and dismissal of the main lawsuit for, quote, lack of prosecution, unquote, meaning that implied environmental racism could not be proven because such intent must be. Got to prove intent. But it wasn't. Many problems and issues remain unresolved, and it involved multiple trial phases, various municipal, state, and federal government entities, including the City of Houston, the Oil and Gas Division of the Texas Railroad Commission, the EPA, and several judges, all but the last recused for various reasons. Too many cooks and crooks spoiled the broth here. That this huge body of partially and or wholly relevant issues, information and misinformation, was brought even into a partial resolution and a reasonable stopping point at all is one of the many skilled achievements of Houston Federal Judge David Hittner, in whose prior 133rd Texas District Court I was a juror in 1981. I'm honored to know him even just for one day, followed by a strong personal interest in his federal career in skillfully judging a slew of hard cases. Hittner was appointed judge for the U.S. District Court for Southern Texas by President Reagan and confirmed by the U.S. Senate in 1986. The settlement of the case against Chevron is credited to an appointed special master. But Judge Hittner, known to me to run an efficient, tight ship, innovative courts, deserves due credit for dismissing the case against Chevron. What is so sad about Kennedy Heights' legal flail is that the mainly black residents who cannot sell out and move elsewhere have seen their affordable American dream homes become unsaleable in their sole domicile choice. Some make the best of it by tending small, tidy homes, lawns, gardens, and pastures in a normally lush green plant environment not suggestive of serious oil pollution hindering plant growth. Horses have long grazed there, and developers built a community atop some sludge that should have been removed long ago, not buried and partly preserved against total slow oxidation by microorganisms. Severe drought since 2010 and not crude oil has impaired plant growth. Still, when I revisited Kennedy Heights this past March, a well-fed herd of cattle and horses grazed on good grass nearby. These blacks had a legitimate cause to suspect environmental racism, by which proper toxic site cleanup is preferentially done in Caucasian neighborhoods, not those mainly inhabited by blacks. Nothing in this paper devoted to reviewing the basic facts and concepts of these events should be misconstrued as insensitivity to the victim's impaired quality of life. It's absolutely not as insensitivity to the victims' to their health problems reported to include widespread lupus, cancer, and other ills, other serious ills. I qualify my use of the word fake applied to the lupus epidemic to emphasize that there is nothing fake about illnesses of Kennedy Heights residents, nor of their pets that died after drinking contaminated surface water there. What is fake was Quinn's overblown, unproven contention that crude oil causes lupus. The medical community did not know what causes lupus during these agonizing 1990s years of attempted arbitration by Chevron, litigation, demagoguery, a threatened nationwide boycott of Chevron, and apparently still does not know what causes lupus. In some 50 years of oil-related work, I have never heard of even one case of lupus among oil field workers, who include not only various fellow well site geologists, but also some engineers, roughnecks, drillers, loggers, tool pushers, and on-site suppliers. The astonishing good health and longevity of most North American oil well firefighters, who either wholly avoided or recovered from accidents, yet waded around in big pools of Kuwait crude oil and sidestepped discarded wartime ordnance there further supports my firm belief that crude oil exposure does not, in fact, cause lupus. Chevron strongly sought to determine the degree of toxicity of the pollution that it inherited by merging Gulf Oil Corporation into it 50 years after the tank farm pollution of 1926, which was worsened by hurricane damage. Chevron, of course, having obtained vast Gulf oil assets, could not merely walk away from collateral liabilities. Otherwise, corporations that make and leave big messes could simply sell out and walk away without anyone being liable for cleanup. Kennedy Heights residents declined arbitration because they seek punitive damages in addition to site cleanup. Hence, Chevron had to fight a difficult, though flawed, lawsuit. One of Chevron's most radical but successful legal moves was to react properly and skillfully to a biased, unwise, inappropriate, arbitrary, and capricious comment by federal judge Kenneth Hoyt. O'Quinn felt snugly comfortable with his good luck of being in a rare black federal judge's court while representing mainly black plaintiffs and accused Chevron of, quote, forum shopping, unquote. Chevron merely did what they had to do by appealing to a higher court in advance of any verdict. Our federal Constitution discourages arbitrary and capricious court conduct. Chevron had properly researched the medical literature and found that lupus preferentially affects blacks. Hoyt said he did not believe that because, quote, white people wrote it, unquote. One wonders if Judge Hoyt would similarly reject out of hand personal medical advice found in literature about sickle cell anemia or lupus, were he diagnosed with either, or ignore our Constitution, Bill of Rights, and Emancipation Proclamation solely because white people wrote them too. Judge Hoyt was criticized by his peers and properly recused, and was fortunately replaced by Judge David Hittner. Adding still more ugliness to the already complex, acrimonious, and libelous litigation, now came the Reverend indeed, Jesse Jackson, of Rainbow Coalition religious fame or notoriety, depending on how you look at it, who polluted my TV set during the 1990s news broadcast by saying, quote, I could settle with Chevron, unquote, bluntly implying that he had some legal case that was purely imaginary, fictitious, and fraudulent. He threatened a nationwide boycott of Chevron, adding yet another difficult but bogus, unjustifiable issue to resolve. Much recent news reported about Jesse Jackson refers to Kenneth R. Timmerman's book about him titled Shakedown. Still for sale and evidently not excluded from the market by any litigation alleging libel. The more recent conviction of former Illinois Congressman Jesse Jackson Jr. ordering jail time backs up Timmerman too. Like father, like son, and both crooks, could any such tall, handsome, well-spoken Reverend Jesse Jackson be truly guilty of blackmail, extortion, fraud, libel, and intended conspiracy to organize an illegal restraint of trade? Shortly thereafter, both Jackson and Chevron abruptly shut up about Kennedy Heights. No comment from either, and a called-off boycott. I have my own personal opinion why, based on the relevant facts as I know them. Pursuant to similar oil pollution litigation in Ecuador, Chevron is being sued after the Texaco-operated oriented jungle oil fields jointly with the government company Petroecuador that still operates them for 28 years starting in 1964. Chevron merged Texaco into it in 2001. Chevron has since sued a lawyer in New York for extortion during these proceedings. There again, we will see how all this plays out. Searches for Kennedy Heights contaminants potentially impairing public health yielded too many dead leads. For example, creosote identified as a contaminant there. Excuse me. Were I the judge and a lawyer told me, aha, creosote obviously caused the lupus cases, I would reply, creosote, so what? This is a public health case. Creosote, like mercury and lead, is almost insoluble in water, hence can't readily traverse our blood and lymph streams. With all that creosote everywhere on telephone poles and railroad tiles, we could have been exposed to tiny amounts of it and developed some tolerance to it, like the smallpox and polio inoculations of tiny amounts of agents that cause those ills. Furthermore, this is probably not the only and not the last either instance of chemical dumpers using the convenience of spilled oil so that they can blame their dumped surplus chemicals on an oil company, walk off and get away with illicit chemicals dumping. Now, let's please digress briefly to mid-1981, when I was a juror in Judge Hittner's well-run 133rd Texas District Court on a traffic collision case, Childress versus Richards. Surely this was an insurance case with no one willing to pay before a court verdict assessed liability. The word insurance could not even be uttered in open court, lest that be grounds for mistrial or jury misconduct. I now believe that Judge Hittner originally deemed this case weak, hearable in one day to be resolved by 5 p.m. sharp. If the plaintiff's version of this collision were accurate, Newton's laws of motion and momentum would need complete revision. Neither lawyer had evidently studied high school physics, hence the virtual junk science plaintiff approach. We found for the defendant, the late Homer Richards, who had died during the several years needed to await his day in court, placing his estate in legal limbo meantime. Judge Hittner is a hard taskmaster for lawyers in his court. The defendant attorney was an apple-cheeked youngster in his first ever case who seemed in awe of an analytical jury, speaking softly and hesitantly. Judge Hittner repeatedly admonished him, shouting, "Speak up, counsel, speak up." Is Judge Hittner a good one? Well prepared to run his court as a taut ship? Surely yes. Is he an innovative judge too? Surely yes. From this and other developments, I was sure that if anyone could judge the Kennedy Heights litigation fairly and well, Judge Hittner could. In the almost 7 years of contract technical writing at Chevron, late 1991 to early 1988, I learned that Chevron is not racist. Among my 550 or so email constituents who read my internal newsletter on evaluation of new computer systems, software, and hardware were 2 black Houston database administrators who appreciated my availability to polish up their written English, and some Nigerians who included some very bright native petroleum engineers in Nigeria. In a letter to an East Texas newspaper, I predicted that Judge Hittner would tolerate no bogus claims in his federal court and would dismiss the Kennedy Heights case against Chevron before he did so. I described the case as Swiss cheese perforated because well-vegetated Kennedy Heights did not show severe oil pollution that would have inhibited plant growth. The medical profession did not know what causes lupus. Crude oil does not, as shown by its absence among all field workers, and further, the city of Houston is responsible for the public water supply, duly filtered, chlorinated, and fluorinated. This is more easily said than done because our Beaumont clay subsurface formation swells when wet and shrinks when dry, causing waterline breaks that must be repaired, flushed out, and reconnected. Still, water customers pay the city for it, not Chevron, that does not sell public tap water. Soon thereafter, Judge Hittner dismissed the case against Chevron. Though Kennedy Heights is surely not in the delightful South Pacific lyric, musical, happy talk, this is not happy talk, why not list some lessons learned here? I've suggested Dr. Orient a round-robin round-robin table, a symposium on how to defeat junk science-based lawsuits. If your case is at least as strong as a plaintiff's against you, filing a countersuit alleging fraud and conspiracy can shorten the time to settle all issues and put your adversaries on the defensive. Let them, not you, sweat for a while. Have a firm prior agreement with your lawyer that he or she is not going to be Mr. Nice Guy or gal and just give away anything of value. If your spouse deserts you and takes out of state a vehicle to which you hold title, then requests authority to get new plates there. Do not merely accommodate that spouse without some reciprocal specific items of value to you, such as a non-appearance waiver in your divorce suit alleging neglect. Withholding vital recent income tax data pending a fair data exchange could work similarly. If your prospective lawyer says, I'm not a detective, still require in advance of paying sufficient retainer that lawyer to do a reasonable amount of pretrial investigation, particularly since the internet now makes the lives of millions of people an international open book. Know in advance of your court appearance the worst case scenario of a damaging judgment against you and the cost and inconvenience to appeal to a higher court likely distant from the original one. If possible, do, quote, forum shop, unquote, for the best court. At least in Texas, where non-federal judges are elected, it's not hard to learn who the best judges are. Self-respecting judges want neither to recuse nor to be appealed. If when choosing an out-of-state lawyer, you are referencing Martindale and Hubble and you are told he's a grade B lawyer who would be good enough, be skeptical. A grade B lawyer may not be good enough. Before retaining a lawyer, have an absolute agreement that in court, that attorney will vigorously cross-examine all witnesses against you and thus protect your interests, particularly your federal Sixth Amendment right to confront your accuser by demanding, how do you know what you say is true? Prove it. Witnesses coerced into a conspiracy to coordinate perjury can be uneasy in court. Such unease can show. If I am sued, a lawyer whom I retain must prior agree to own and be experienced with an up-to-date cell telephone and or iPad to access the internet and have it available during business hours. As a theoretical example, let's say I am sued with allegations that I know are false and arrive in court to learn that a Mr. Joe Blow from Idaho, of whom I've never heard, I haven't been in Idaho for 20 years, no longer know anyone there, is a so-called witness prepared to testify against me. About all I can deem a fact is that Mr. Blow is after some of my money. My lawyer could, without delay, surf the internet, searching for Joe or Joseph Blow ID for Idaho, and whatever information, and notice whatever information appears on the internet. Possibly there is some negative data that Mr. Blow would be uneasy about discussing under oath on cross-examination. That way the advantage of surprise would move from me to Mr. Blow, as it well should if he intends coordinated perjury to support fraud in court. Know your professional ethics and those of witnesses against you. If there is obviously a conspiracy to perpetrate perjury and fraud against you and the judge seems about to fail to protect his own court against such abuse, and ask you such a snotty question as, what other legal trouble are you in? And you are not, try responding, Your Honor, in recent years I have not had a speeding ticket or even a parking ticket. Your question seems to presume guilt, so please consider recusal. Defense lawyers generally like analytical jurors. Plaintiff lawyers generally don't. My own lawyer had a sense of humor as evidenced by his Christmas card showing Santa Claus on trial for trespassing and roof damage, being tried by a jury of 12 friendly reindeer and captioned, now that's how to pick a jury. When I am asked how to be excused from a jury panel, I just reply, sound analytical as all hell. The plaintiff lawyer will likely say, excused if you do. Okay, with the appropriate legal dirty work behind us, let's examine the remarkable health of our oil well firefighters, who are so few as that a brief summary is not difficult. Number 3. That's it, yeah, okay. Safety-conscious old-timey civil aviators long had a saying, there are old pilots and there are bold pilots, and there are no old, bold pilots. This is true of such pioneer aviators as Wiley Post and Amelia Earhart Putnam, who died too young, but is untrue of such old, bold pilots as Charles Lindbergh and Jacqueline Cochran, who died natural deaths at ages 72 and 74, respectively. Now, with such astronauts as Dr. Harrison Schmitt and Mike Kelly, not to mention Neil Armstrong, who enjoyed, or either still enjoying or did enjoy, a ripe old age of a natural death, and of course, Dr. Schmidt's still around, and so is Mark Kelly. This saying is obviously untrue. Surely the oil well firefighters are among the boldest, most courageous, and noble men on our planet who protect it like no others do from air and water pollution. The pioneer oil well firefighter Myron Kinley lost a cousin, and the old-time firefighter William H. Patton lost a brother and an arm in fire accidents. Still, I am impressed by the durability of these bold, resourceful men, herein identified with their ages of natural deaths as follows: W.H. Patton and Red Adair, 89. Joe R. Bowden, Sr., founder of Wild Well Control, Inc., 74. Myron Kinley, 80. Edward Coots Matthews of Boots and Coots, Inc., 86. Other survivors of this unusually dangerous, grueling work include Asger Boots Hansen, retired co-founder of Boots and Coots, and a year older than I am, and I'm 86. I've tried to support and attend all annual offshore technology conferences, OTCs, held in Houston in May because OTCs are global class environmental protection forums and a big boost to world peace and understanding, bringing together as they do many of the world's boldest, most resourceful innovators, their cultures, faiths, and languages. Self-ordained armchair environmentalists, being effete anti-educational snobs as are most of them, are conspicuous by their absences at OTC. I make a point to visit the oil well firefighters OTC exhibits and thank them again for the phenomenal work that they do in oil fields of all continents except Antarctica, where none are known. I'm further impressed by their almost casual, we just do our jobs attitudes, seldom if ever personally self-laudatory. To a man with whom I've talked, they deemed it an honor to extinguish the Kuwait fires. They make relatively little of their achievements, which they mostly deem routine. For example, Neil Adams, a Houston-based pioneer in computer applications to drilling, just returned from Kuwait, looked fine as ever, and matter of factly told me that it was an honor to help extinguish the Kuwait fires. In one such post-Kuwait personal conversation with the late Coots Matthews, he confirmed that he had been examined by Duke University's medical school to determine if he had any lasting medical ills from breathing the polluted air and walking around in the big pools of crude oil that followed extinguishing fires before capping the wells. All tests were negative, so Duke doctors quit examining him after running their gamut of diagnostic tests. Coots casually explained in his words, "We always work upwind of a burning well." For oil field workers who can avoid accidents or at least survive them, outdoor oil field work in general and firefighting in particular seem remarkably healthy careers, perhaps even enhancing longevity, if you can believe that. But don't try this at home. The yellow inset map, there in the yellow, shows Bergan Field with small white circles, which, those of you who are fairly close to front may be able to see those small white circles. Here's the Bergan Field there. Those small white circles are gathering systems. The upper map, the Bergan Field was, during the Bush 1 administration, was the world's most prolific onshore one. Most commercial oil fields are shown in green and gas in red. The upper map on a different scale, shows known oil fields in the same general south-north trend, producing like Bergan, mainly from sandstones of the Cretaceous age, the last period of such familiar dinosaurs as Tyrannosaurus rex. The evil tyrant Saddam Hussein's pretext for invading and occupying Kuwait was that the excellent Rumaila oil field straddles the international border, and that Kuwait was draining Iraqi oil and cheating on its OPEC quotas, as most OPEC members that could routinely did. Southward, off the map, are many Saudi Arabian fields producing hydrocarbons from Jurassic limestones. Shown in the larger map in Iraq and Iran are some major onshore petroleum fields producing from porous and or naturally fractured Miocene limestones aged between 11 and 25 million years. Kuwait, a Kirkuk oil field in central Iraq, northward off these maps, was long Iraq's main oil field, producing oil with so much associated gas that 7 degassing stations had been commissioned by 1958. The Kirkuk area's gas seeps were so prolific that they were long subject to artificial ignition. There was some opinion to the effect that the fiery furnace mentioned in the book of Daniel was fueled by such gas seeps. Bergan oil field was mainly outlined with 211 vertical oil wells by year-end 1958, when 40 oil wells and no dry holes were completed in Kuwait in 296,256 feet of drilling for an average depth of 7,406 feet, 7,406 feet. And 11 Bergan gathering stations were in use then. Subsequent infill drilling seems complete, with the first 2 Bergan multilateral deviated wells drilled within the last 3 years. So the field, despite the extreme depletion when the wells were on fire, is not done with yet. U.S. commanders had little respect for Iraqi military strategy because, among other flawed mindsets, Iraq was convinced that U.S. Marines would land amphibiously on Kuwait beaches, hence armed the latter to the teeth. This had no positive military effect, but made the firefighters' dangerous work even more so, what with all the ordnance and obstacles placed between Bergan Field and the sea. The U.S. Army made no secret there was basically no-brainer intention to make a mechanized desert end run, which would go right around Kuwait and into Iraq and trap the Iraqis retreating from Kuwait northward, get them entrapped. And what they did was they captured some of the Iraqi conscript, the Iraqi troops, and sent them back to their own fellow troops after warning them what was in store for them. So when Operation Desert Storm started, long lines of Kurdish conscripts walked into Saudi Arabia with their hands behind their heads, seeking political asylum. And that was one of the most amazing things I think I've ever seen on television, is an army en masse surrendering to do that. Of course, the Kurds were very unfairly treated in the Iraqi army, so it's not hard to see why they did that. Before retreating back into Iraq, Iraqi engineers laid an oil pipeline into the Persian Gulf to pollute it with Bergan field crude from selected wells, not set afire as an additional act of war against Saudi Arabia. This engineering boondoggle failed too. The late firefighter Larry H. Flack told me later that these unwise Iraqis overlooked the fact that oil floats on water. The Saudi desalination plants that Iraq sought to sabotage drew from intermediate depths to avoid taking in seawater either from such floating debris as seaweed or jellyfish, or such seafloor matter as crabs, sand, and mud. The firefighters needed ample water. Being field experienced, they merely reversed the Iraqi oil line quickly as a water line and pumped adequate seawater directly into the flow lines to pits and tanks and proceeded to extinguish 698 burning wells in less than a year, something like 7 months. Firefighters tried many ingenious methods and substances, particularly water and nitrogen, either gaseous or liquid. What seemed anomalous is their use of high explosives, or what may seem anomalous, is their use of high explosives on burning wells. But remember from high school chemistry that fire is rapid oxidation. That works both ways to aid rapid fire extinguishing. Explosives can and often do convert all localized free oxygen to such other non-combustible gases as carbon dioxide and nitrogen in a well's immediate vicinity, killing fires instantly. In some instances, a big canister of liquid nitrogen sprayed on a burning well can extinguish it. Of course, white hot steel and renewed oxygen's presence can and sometimes do cause reignition. Flaming dry gas wells are a bit easier to handle since once the fire is out, because expanding gas cools, being a basic process of modern refrigeration. Writer Ward Harkavy did a good post-Kuwait interview of Boots Hansen in the Village Voice titled "How to Fight a Hellfire." Ward said, quote, "The biggest threat is what those in the business call the unexpected vapor cloud, which can ignite at any time. Putting out the fire is not the big job. Capping the well is," unquote. While custom-made 78,000-pound bulldozers and other heavy equipment were airlifted in, firefighters assessed the situation via helicopter and jeep, and they determined that, among other information, that Kuwait's winds are mainly from the northwest. This, of course, is consistent with experience of offshore Permian Gulf drillers hardly able to see what they're doing when they're during the severe sandstorms that blow sand off the Arabian desert. Hence, million-gallon plastic-lined water pits were dug northwest of each burning well. Hansen was reported to have used a bulldozer-mounted 60-foot horizontal crane called a tush hog to lower 30-inch diameter pipes over burning wells to focus the spraying fires upward vertically. Then the firefighters would try to pump water or nitrogen into a side valve to quench the fire, or use explosives to deprive the fire of oxygen momentarily. My story is marred a lot at this point by the very tragic death during recent years of Larry H. Flack and several others on a fishing boat they were returning at night to Houma, Louisiana, collided with a barge. Larry was a vigorous, well-spoken petroleum engineer who served the industry well and who would surely have lived to a ripe senior age had he survived this accident, entirely unrelated to his work. By naming the U.S. oil well firefighters only as I've known them, should not imply that our nation is the only one or even has the best of the world's firefighters, oil well firefighters. A Canadian firm, Safety Boss Incorporated, did itself proud in Kuwait. Larry Flack spoke well, too, of Muslim teams from Iran and Egypt. The requirement that Muslims pray 5 times daily seems not to have been a problem in Kuwait. Red China has oil well firefighters. Perhaps the most unusual, most publicized ones were Hungarians who almost literally beat swords into plowshares by applying surplus Soviet Army tanks and MiG jet fighter and aircraft engines. In one application, a high-velocity forward Soviet Army tank cannon was converted into a huge nozzle to spray high-pressure water onto burning wells. Another innovation was a veritable Rube Goldberg application of a military tank with jet aircraft engines mounted backwards but forward on the tank. It worked. How? Remember that when we blow out birthday candles, we blow moist oxygen-depleted nitrogen and CO2 onto them. This unique Hungarian contraption, applying updated Russian concepts, blasted oxygen-depleted jet fuel exhaust fumes and moisture onto burning wells to kill the fires. Another example of technical innovation and resourcefulness was also explained to me by the late Larry H. Flack, who was employed post-Kuwait by Halliburton. When the U.S. invaded in 2003, Saddam Hussein ordered that Iraqi oil wells be torched as a scorched earth policy, and explosives were placed downhole to be detonated remotely. Then radio frequencies were jammed to disable this function. Distributed propaganda leaflets asking Iraqis not to destroy their national oil resources, as Saddam ordered, had their good effect too. Hence, only 9 Iraqi oil well fires had to be routinely put out as coalition troops advanced on Baghdad. Finally, though the noble, talented, courageous, resourceful oil well firefighters who make so little of their phenomenal work wouldn't claim this, I contend that they have served modern history beyond just putting out huge fires and are strong influences enhancing world peace. After 5 months battling the Hassituel, Algeria gas blowout and fire in April 1962, the late Red Adair put out what the Arabs called the devil's cigarette lighter. Like other Arabs, Algerians generally disapprove of our support of Israel, but they surely want the U.S. oil well firefighters back in Algeria as needed. During the Iraq-Iran war, Iran invited some U.S. oil well firefighters to put out some fires caused by Iraqi military action. So the firefighters sought guidance of the Carter White House that asked them to hold off pending resolution of Iran's act of war by invading the U.S. Embassy in Tehran and holding our State Department personnel hostage. Our firefighters then passed up some well-paying work. They did as the White House asked. Meantime, out of sheer necessity, National Iranian Oil Company trained a competent firefighting unit that assisted later in Kuwait. Algeria was reported as a main broker to get our hostages released in early 1981. Please think about this. Do you connect these historical dots as I do? Well, folks, after tomorrow's interesting Ad Astra rocket company plant visit, let's go back home. Were I President of the United States, I would happily pin medals of freedom on 2 Colorado School of Mines alumni who killed the disastrous Macondo blowout well offshore Louisiana in mid-2011, Bill McElduff and Donald Fitterer. Using directional drilling and magnetic orientation tools, they hit a dinner-sized plate target from a 3-mile vertical distance from a floating platform a mile above the Gulf of Mexico floor. That's a phenomenal story in itself, but I'm not about to abuse your time and patience, so I'll leave it at that. So I respectfully urge you to have a safe trip home. Do buckle your seat belts and require your passengers to do the same. It's the law. Thank you very kindly for your attention. I'll shut up now except to try to answer whatever questions you may have. Okay, that's it. Okay.
Yeah. Quick question on the on the Petroleum Reserve. You're probably familiar with that. I was just curious. The politicians sometimes say, "Hey, we can supply some gasoline," and then I think it's understood that basically you can reduce the price of a gallon of gas a few pennies by depleting our strategic petroleum reserve. I presume this is still in the salt mines in Louisiana?
Yeah.
I'm just curious what quantity is stored there at this time? In other words, is it half full, whatever? I just was curious.
I've never heard any complaints about the quality of it. Now, that what they've done.
No, quantity, sir, quantity.
Not quantity, okay.
Yes.
Yeah, it's pretty much advertised as a 30-day supply at current demand. And so that's not much. So I've never thought it was a particularly good idea because I think it's a lot better to encourage a real strong domestic oil industry that's got plenty of people operating it rather than try to put that stuff in cold storage. I do have also some questions about is it going to dissolve out some of the salt and get in the crude oil? because I think that can happen. And one of the big things in the refining process is to get the salt out of the oil. And there's a lot of effort to desalting because crude oil generally is not all that pure as you like to see it. A lot of things have to be taken out, a lot of contaminants, including salt and including some metals and things of that nature. So I never thought it was a good idea, but as long as we have it, and it's probably something that is an asset, and the government can make money out of it because as oil prices go up, then they will hopefully get more money per barrel for it when they sell it. But I think it's kind of an out-of-date concept in view of the shale gas and oil boom.